Hello, I'm Caroline Barker, part of the Healthcare Regulatory team at HCR Law. Today I'm joined by my colleague Laura Shelton, who is a partner in the Healthcare Regulatory team too. And today we are going to be talking about CQC inspections, the reports that arise from them and how providers can challenge these. So welcome, Laura. The first question probably that providers want to know is why should they consider challenging their inspection report in the first place?
The glaringly obvious response to that, first and foremost, is of course the ratings and the colours on the inspection report that service users and their families are going to look at when they're deciding whether or not they should place someone with your service, if it's adult social care, or if they should use your service more generally. More broadly speaking though, there's a whole load of factors into why you might want to challenge. I mean, there has been a lot of change at CQC, and I don't just mean recently, I mean over the years, in terms of re-inspection timeframes. There used to be a bit more of a definite piece of guidance about when you could expect to see CQC again. But at the moment, there is a long gap in a lot of cases between CQC inspecting and then re-inspecting. So providers have to think quite carefully about whether their rating as it stands is fair and accurate, and whether it's one that they want to have in the public domain for a long period of time. In addition to all of these considerations, there's also just having the correct narrative about your service in the public domain. Sometimes providers will challenge reports, changes will be minimal, perhaps ratings won't change, but there will be change to specific wording or connotations within the report which are important to providers, particularly in different sectors. This can have an impact. For example, for a long time, we were seeing providers of services for people with learning disabilities and autism receive inspection reports that were saying things like, you're not providing care in line with registering the right support, or right support, right care, right culture, as it became. And that can be potentially damaging and create a narrative where CQC might look to take further action down the line. And another reason to challenge is regulatory breaches. It's easy for providers to fall into the thinking that inspections are almost just operational, but they do fall out of legislation and the legal requirements that are placed on them. If CQC say that you're in breach of a regulation and you don't think that's justified, perhaps there's not enough evidence or it doesn't meet that high bar, that may be something you want to take out of the inspection report to make sure the report's up to date, but also to make sure that it doesn't start a spiral of future enforcement action. The same can be said with, repeated inadequate ratings will require CQC to look at enforcement action, but the same can be said for repeated requires improvement ratings. Finally, you just want to be aware of the wider circumstances in which you're operating. It may be that your commissioners may not place with you if your requires improvement. You may be trying to refinance, get funding. Lenders may have specific restrictions in relation to what they consider the appropriate ratings have to be. So there's a whole range of things to take into account, and a decision has to be made within a short period of time about whether or not to make that challenge.
Okay, so if a provider receives a draft report that they're not happy with, what is the process for challenging that report?
CQC has guidance about this on its website, which throughout various changes in the inspection model, the factual accuracy process actually hasn't changed that much. The key thing to note is that you have 10 working days from the date that you received your inspection report, which initially might feel like a long time, but if you have to do a forensic challenge, you do want to think about acting quickly. You would prepare your challenge at the moment through the provider portal. You can challenge things like inaccurate facts. They are the obvious things to challenge. You can also challenge things like ratings and also regulatory breaches. I've been doing this for a very long time, and there have been periods of time where the Care Quality Commission have been responding to factual accuracy comments to say things like, when you're challenging ratings or regulatory breaches, that factual accuracy comments isn't the appropriate mechanism to do this. You should follow the rating review process. However, when you look at the rating review process, it's very limited in scope, and it relates only to procedural errors and specifically talks about not challenging ratings through that process or also regulatory breaches. And so without getting into too much of the detail of the arguments that could be had, if you are getting pushback in your responses about that, the correct position is, and it did feature in CQC's guidance latterly, that this is the most appropriate forum for you to challenge things like your ratings and your regulatory breaches. In addition to challenging factual accuracy, judgments, ratings, etc., and the position as at the time of inspection, if you like, providers will note that if they look at CQC's guidance, they're also quite clear that you can also provide evidence of improvements that you've made since the inspection. Now, there is a distinction here in terms of how CQC will use that information. What they say in their guidance is that they will take it into account. They will consider whether the report should be amended, but they do specifically say that for evidence post-inspection, it won't be used to affect the rating. I think there are different arguments to be had about that. I think it depends on how quickly you provide the information. So, for example, if you provide it when you've had your feedback, but before you have the draft report, I think in those circumstances, there's a stronger argument to be made that it could impact the rating. But it is worth still providing that information if you have made improvements, especially when things like regulatory breaches are at issue. Because as I discussed at the start, it can be a really long time before you're re-inspected. Again, it can also be a really long time between being inspected and your report actually being published. And if you want to make sure that the report is the most accurate reflection of your service, okay, yes, there was an issue on the day of the inspection, but that's been resolved. We've evidenced that to CQC, and you want that in your report so that readers of the report are reassured that that's no longer a concern.
Okay, I mean, sometimes we have providers who are a little bit concerned about pushing back with the CQC. In your opinion, will it damage a provider's relationship with the CQC if they do challenge an inspection report? And what if there are no changes as a result of challenging that inspection report?
Two good questions that I get very often when I'm first speaking to providers thinking about challenging inspection reports. I suppose maybe we should think about it more in the terms of responding to inspection reports, because you can, of course, look for improved ratings for things like good to outstanding, and that would be less about trying to challenge judgments and ratings and more about collaborating with the regulator and providing information that you think should have been taken into account. However, as we talked about when we were talking about the considerations as to why you might challenge, there are a number of stakeholders that will have an interest in your rating and the judgments that the Care Quality Commission have made. Therefore, it is important for the provider to think about the bigger picture, if you like, and whether to balance challenging versus not challenging and the impact. CQC should look at them, impartially. In fact, at one stage in the process, there should be review of someone independent of the inspection team. But yes, it can be a judgment call. What I would say is I have seen circumstances in my practice where a provider has decided not to challenge the regulator because they think it'll upset the regulator or there's no point, no changes will be made. But they found themselves in circumstances where failing to challenge a report led to warning notices, which they didn't respond to, which led to a notice of proposal. And of course, in notices of proposal and enforcement action, CQC do look at regulatory history. And the provider was telling me, oh yeah, well, that's what they're saying, but that wasn't actually the position at the time of the inspection. However, they didn't challenge that at the time, and it is very difficult to sort of go back and reverse that narrative. So it's definitely something to think about really carefully. In terms of what if you don't get the outcome that you're looking for, I think it's really important when we work with providers, managing expectations is a key part of this. And I think encouraging the provider to be reflective as well. Sometimes immediately post-inspection we'll get a phone call, or sometimes even during the inspection we'll get a phone call about, this is really unfair, this is not a true reflection of the service. And perhaps when the provider goes back to think about it, there are some things that they need to or would want to think about improving. I think you want to look at it, take a step back, think about whether the ratings are justified, whether the regulatory breaches are evidenced, and that's important because it's a legal test. It's not just a decision for CQC to take lightly. And that is one area where I have seen, and this has happened in a lot of the cases I've worked on actually, where we've challenged inspection reports, and whilst the rating hasn't changed, the breaches of the regulation have come out. Now, for me, that's almost a better result because it helps to minimise the risk of future enforcement action. But of course, everyone wants to see the green or the stars. If a provider's not happy, you can try to submit a rating review. That can be difficult, because it is based on procedural errors. There are circumstances when rating reviews can be submitted, and there are circumstances where a failure to properly consider the response could amount to a procedural error, and there are bits and pieces of case law and that type of thing. There is, of course, also the avenue of judicial review. CQC is a public body. They have to act within the scope of their powers. Now, no one wants to rush straight to the door of court, and certainly that's not something that we would be encouraging. But there are cases, and that's what the case law that we have arises out of. So, there are circumstances. I would say each turns on its own facts, and it's important to get advice. But most importantly, the factual accuracy comments are the foundation. That's where you want to get all your information in. And even thinking about those cases that end up at court, the factual accuracy comments are part of the bundle. So that's where you want to get everything in, comprehensive, evidence-based, and take it from there. What you can also do is if your challenge isn't successful in the way that you would like it to be, you can also engage with the bodies that are interested in the report. Now, the first people would be service users and families and your staff, because staff, they'll be really demoralised potentially by an adverse inspection report. So I think it's important to explain to those stakeholders the steps that you've taken or why you don't consider the reports appropriate. You could, if you wanted to, put something on your own website. You could write to commissioners, you could write to funders, local authorities. You could provide them with copies of your factual accuracy response. But I think it is important at the end of the day, as a provider, that you have put your position on record as to what you think that the state of play at the service is and why you don't think the rating is justified.
So the moral of the story is go through your report carefully when it arrives, check whether you agree with it, and if you don't, put on record why you don't agree.
Exactly.
Well, that's really useful. Thank you very much, Laura.